Hello, friends. Patrick McFarland here, coming at you with episode 63 of the Liberty Weekly podcast. This one will be available on BitChute and YouTube. It will be embedded, though, in the show notes page at libertyweekly.net/63. And today I wanted to talk about gun rights and Justice John Paul Stevens' op-ed in the New York Times that he wrote about the March for Our Lives, saying that we need to repeal the Second Amendment if people want any lasting change. And not surprising coming from Justice Stevens, as we'll get to here in the future, in the later part of this show. However, I wanted to stress that, as a voluntarist, I don't think that we need to look to the Constitution or the Second Amendment to argue that we have natural rights to defend ourselves. And we'll get into that, but I think that it's folly to ignore, just because, we don't believe in the Constitution or we don't believe that a document written 200 years ago that we never signed has any authority over us. Just as we believe that doesn't mean that we can or that we should ignore what's happening in the Supreme Court or in the normie sphere where people believe in the myth of political authority. So I think it's important to be the smartest person in the room, and to that, I will offer this presentation here. So let's get right into it. Here's the op-ed in the New York Times by Justice John Paul Stevens. And he says, we had this rally with all these children who were screeching autistically about gun control and, appealing to emotion. And he gives that credence. These children have been around for what? A decade and a half. We should definitely look to them to shape our policy and look to their wisdom. So they demand respect, is what he says. And now, because we had a bunch of screeching children go on these marches, and I guess they were joined by some adults, it was mostly adults on the marches, we should, just forget about the Second Amendment or repeal it for lasting change. He says that the support that we saw is a clear indication that a lot of people want gun control. I think that's not necessarily true. I think there's a silent majority of people in this country that like gun rights. And then he says that a concern for a national standing army and the concern that the standing army might pose a threat to the security of the states was the intention of the Second Amendment, and that's antiquated because the federal government would never come in and, like an alphabet soup agency, trust us, would never come in to threaten you, Waco, and, Ruby Ridge and all these other things. So, yeah, we don't need protection from a standing army anymore, the federal government. So that's antiquated. We should get rid of that. It's a relic. For over 200 years, so he's describing the precedent of the Supreme Court and specifically refers to Justice Warren Burger as setting out precedent that just because we have the Second Amendment doesn't mean we can't regulate gun ownership federally. And that was the reasoning of the court that he recounts, which I think is garbage because the states have police power traditionally. And I don't think that the Constitution is a limiting document, and correct me if I'm wrong, but I don't think there's no power delegated to the federal government to prevent individual citizens from possessing firearms. And I wanted to get into this later, but I'll just jump into it now, just talking about how in the Constitution being a limiting document, and there were a lot of anti-federalists, people who were skeptical of the Constitution, who thought that we shouldn't have a Bill of Rights because the implication being the Bill of Rights is meant to limit the power of the government and say, these are lines that you definitely can't cross. Well, the anti-federalists were saying, well, if we have a list of 10 things that the government can never do, that would infer logically that the government would possess the power to infringe those things, when the entire point of the Constitution was to limit the federal government to only the things expressly delegated to it. And if you give the Constitution credence, if you're a constitutionalist, which I say, if the Constitution has no authority, but even if it did, you wouldn't be able to do the things that you want to do. But just continuing on, he talks about the Heller decision and how it has given fuel to the NRA, which is the NRA is actually a moderate gun control organization, and they're not radical enough. But he's saying, oh, it gave the NRA fire to, block gun control regulation, and that's terrible. And so if we want, the simple but dramatic action of repealing the Second Amendment, great idea. It's second for a reason. It's, pretty important, right under the First Amendment. But so, that's Justice John Paul Stevens, but it shouldn't surprise anyone that he's saying these things like this. And so let's go on to that. This is Oyez, or Oyez.com. This is for law students. This is the Supreme Court Center. And this is John Paul Stevens' biography. He actually was not from an Ivy League school, which is what I was thinking about in the shower right before I filmed this, is, most Supreme Court justices are either from Harvard or Yale, so you get, the elites, they have so much power that we'll get into later with judicial review. That is the ability of the Supreme Court to strike down laws, and that is actually a bit unique to our constitutional system. It doesn't exist in Great Britain, which is what our system is based off of, is Great Britain's system. Loosely, of course, but it is different. So what I was getting to with the Ivy League schools is that, Skull and Bones is at Yale, so you get the secret society and influences affecting the elites. I'm not saying, the conspiracy theories, but you get the elites affecting the Supreme Court justices. And the fact that most of them come from Harvard or Yale, I think is, it's telling. I think it's telling. So just recounting John Paul Stevens, he's from Chicago, which is a cesspool. Sorry, all my listeners from Chicago. I think there's a few, but not a big fan of Chicago or Milwaukee or that kind of area. But Barack Obama was from Chicago. I just don't like Chicago. We know all the gun control legislation is from Chicago. I think that's been stated quite a bit. But so he came from a not a lot of means. He was from a poor background. No, the Stevens were one of Chicago's wealthiest families with a business empire that included what was then the world's largest hotel. And so he faced adversity because his father died from a stroke. They were indicted on it. Wow, I'm just not doing very well. So this article says that his father, his uncle, and his grandfather were all indicted on embezzlement charges. And so his uncle, so there was some, whatever, that's not important. But so he went on to clerk. He was involved in a whole bunch of landmark decisions. But the most important part of this, I didn't want to recount his whole career. He's obviously a liberal justice. But he retired on June 29th, 2010 at age 90. And it says here, in 2014, Justice Stevens testified before a Senate committee to criticize recent Supreme Court decisions that weaken spending limits in political campaigns. And the thing they note to say here about him is that even in retirement, Justice Stevens remains an active participant in the formation of Supreme Court decisions. Well, screw that. He's out. Get him out. That angered me. But in any sense, here's the page on the Heller decision. And so here are the facts of the case. For all you that are listening in the audio version, I'll just read it off. But for you watching the video, you can read it yourself. So the facts of the case are, it was decided on June 26, 2008. And the facts are that the provisions of the District of Columbia Code made it illegal to carry an unregistered firearm and prohibited the registration of handguns, though the chief of police could issue one-year licenses for handguns. The code also contained provisions that required owners of lawfully registered firearms to keep them unloaded and disassembled or bound by a trigger lock or other similar device unless the firearms were located in a place of business or being used for legal recreational activity. Screw that. Dick Anthony Heller was a D.C. special police officer who was authorized to carry a handgun while on duty. And I think it's ironic here that a police officer, a special police officer, him being the one that would be, police officers being the one that would carry out gun confiscation, I think it's ironic that in this instance, a police officer is the one who sued to protect gun rights. So I don't know much about him specifically, but maybe he's a hero in some sense. I mean, he is a police officer, so I'd temper that message. But fighting for gun rights, even though he'd be the one that took them away, I don't know. But he'd be the one that would take them away, excuse me. But so he applied for a 1-year license for a handgun. He wished to keep it home, but his application was denied. Then he sued the District of Columbia, seeking an injunction against the enforcement of the relevant parts of the code, and argued that they violated his Second Amendment right to keep a functional firearm in his home without a license. So at the district level, the district court dismissed his complaint, saying, "Get out of here. We're not gonna, we're gonna hold you to the law. We're not gonna strike it down." However, the D.C. Court of Appeals for the District of Columbia Circuit reversed and held that the Second Amendment protects the right to keep firearms in the home for the purpose of self-defense, and that the District of Columbia's requirement that firearms be kept in the home non-functionally violated the right. So in the district court, they dismiss his complaint, and then at the next level, I think this is the federal U.S. Court of Appeals for the District of Columbia reversed the decision and held that the Second Amendment protects the right. So he filed at federal court in the district level, the district D.C. level, and it was appealed and overturned by the District Court of Columbia, which is a federal court. Not to be confused with the Warren v. District of Columbia case, and that case, which I've done in Liberty Weekly before. I don't have it up here. If you type in Warren v. District of Columbia here, it'll come up. I think it's episode 47, but don't hold me to that. libertyweekly.net/47. But in that case, that was a state court. It wasn't a federal court. Just need to make that decision that distinction over and over again. But so here are the facts of the case. The question is, do the provisions of the District of Columbia Code that restrict the licensing of handguns and require licensed firearms kept in the home to be kept non-functional, does that violate the Second Amendment? Well, the Supreme Court decided yes, it did violate the Second Amendment. And this was a landmark case, as John Paul Stevens was saying in his opinion in the New York Times, that this was a landmark case that reversed a lot of the precedent that was established in the 20th century through the court. And that makes it very important. And the majority opinion was written by Antonin Scalia, which is, Scalia is a conservative. He's not a libertarian, but he has handed down judgments, and he has been, written the majority opinions that have been friendly for some libertarian causes. And I'd rather have him than Stevens, is what I'm saying. And this is a really good opinion because you get the smackdown of all of Stevens' arguments. And who better to do that than Justice Scalia? Because in law school, if you're in law school, although Justice Scalia is dead, he died when I was in law school, and we found out actually in one of my classes. But if you're in law school, Scalia writes very colorful opinions, and he's entertaining to read. So here's the reasoning. I'll include a link to this page, all these pages in the show notes page, but here's the reasoning, and I'll read it out verbatim just for the benefit of the audio-only podcast listeners. But it says, the ban on registering handguns and the requirement to keep guns in the home disassembled or non-functional with a trigger lock mechanism violates the Second Amendment. Justice Scalia delivered the opinion for the 5-4 majority. So 5-4, meaning that that the majority opinion won only slightly. So we were that close. The court held that the first clause of the Second Amendment that references a militia is a prefatory clause that does not limit the operative clause of the amendment, and we'll get into what that means later. Additionally, the term militia should not be confined to those serving in the military because at the time, the term referred to all able-bodied men who are capable of being called to such service. To read the amendment as limiting the right to bear arms only to those in a governed military force would be to create exactly the type of state-sponsored force against which the amendment was meant to protect people. Because the text of the amendment would read in the manner that gives the greatest effect to the plain meaning, it would have had at the time it was written the operative clause should be read to, quote, guarantee an individual right to possess and carry weapons in case of confrontation. This reading is also in line with legal writing of the time and subsequent scholarship. Therefore, banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting firearms from being kept functional in the home, the area traditionally in need of protection, does violate the Second Amendment. So in his dissent, John Paul Stevens wrote that the Second Amendment does not create an unlimited right to possess guns for self-defense purposes. Instead, the most natural reading of the amendment is that it protects the right to keep and bear arms for certain military purposes, but does not curtail the legislature's power to regulate non-military use and ownership of weapons. Justice Stevens argued that the amendment states its purpose specifically in relation to state militias and does not address the right to use firearms in self-defense, which is particularly striking in light of some of similar state provisions from the same time that do so. Justice Stevens also notes that the people does not enlarge the protected group beyond the context of service in a state-regulated militia. This reading is in line with legal writing of the time that contextualizes the amendment in relation to state militias and post-enactment legislative history. Justices David Souter, Ruth Bader Ginsburg, and Stephen Breyer joined in the dissent. Of course they did. Justice Breyer also wrote a separate dissent in which he argued that the Second Amendment protects militia-related, not self-defense-related interests, and it does not provide absolute protection from government intervention in those interests. Historical evidence from the time of ratification indicates that colonial laws regulated the storage and use of firearms in the home. Justice Breyer argued that the court should adopt an interest balancing test to determine when the government interests were sufficiently weighty to justify the proposed regulation. In this case, because the interest balancing turns on the type of analysis that the legislature, not the court, is best positioned to take, the court should defer to the legislature and uphold the restrictions. Justices Stevens, Souter, and Ginsburg joined the dissent. So just a note on that last little bit here, Justice Breyer arguing that so if you study constitutional law, the Supreme Court uses a lot of these balancing tests, these interest balancing tests. And I think the interesting part about it is that when you say we have, I'm going to make myself big here. The interesting part about it is that when we say that we have natural rights, even the Supreme Court doesn't see those rights as being absolute, because the entire point of the court is to balance the strength of those rights against the government's interest in regulating the rights. So to them, no right is absolute, not even the First Amendment, obviously not the Second Amendment, not the Fourth Amendment or the Fifth or the Sixth. You have these balancing tests that balance legitimate government interests against natural rights. They limit them. By definition, these balancing tests do. And the entire problem comes in, everything is more complicated when you have public property or a public domain. And I think it's all arbitrary, because what they do is they balance, they can say it's not arbitrary in that, we go into really good detail and we have the precedent and we figure it out real good. But it's all arbitrary in my opinion. How do you all of 14th Amendment law is arbitrary like this. They pick certain classes that deserve more protection, and there's different levels. There's strict scrutiny, which the government would have to meet that this is a narrowly tailored interest, and that it will, it's only for specific purposes, and they have a compelling governmental interest, and the regulation, the law is compelling and narrowly tailored. But they also have intermediate scrutiny, where certain protected groups, in order for the government to have a law that affects certain protected groups, the government has to meet intermediate scrutiny, which is one of the lowest burdens, just showing that the law addresses a specific certain problem. And I think it's, I'm getting in the weeds here, but I think it's just so arbitrary. And the fact that I'm not a fan of the Supreme Court at all. Maybe this would be a good time to get into judicial review before I get into the meat of the opinion itself. So coming back here, to recoup, judicial review is the power of the Supreme Court to strike down laws. And I would refer everyone to my episode here that I did, Liberation Library 3, The Truth About Judicial Review. In here, I discuss what I'm about to just briefly go over. So I would point you to this one. That's at libertyweekly.net/LL3, the letters LL and the number 3. But I talk about how this goes all the way back to Marbury versus Madison, establishing what the role of the Supreme Court would be after the Constitution came out, because no one really knew. Once the Constitution was ratified and by all the states, no one really knew what that meant de facto, what it meant in effect. And so you have the Supreme Court grappling with their own role. And this has to do with questions of sovereignty too, where the sovereignty lies. We had it being popular sovereignty in the United States, as opposed to it was legislative sovereignty in Great Britain before then. But now we have popular sovereignty. The people are the ultimate sovereigns, and they hold the ultimate political power. Well, when you have the Supreme Court, what is their role? Well, the role is, according to Marbury versus Madison, we have the power of judicial review, which is to review laws that are made by the legislature and strike them down if they're unconstitutional. Well, there's a nuance to that I cover in judicial review. I don't think judicial review should exist, except, when it is a clear thing, when a case clearly violates the Constitution, when a law clearly violates the Constitution. Of course, the Supreme Court should strike it down. But when it's a question like this, when it's a question of, well, it could go either way, I think that the Supreme Court should shoot the law back to the legislature and have the people decide. And my reasoning is only if we take for granted that the government is valid. If we take for granted that the Constitution is legitimate, which it's not, and I'd point everyone towards libertyweekly.net/28, seeing on screen here, Liberty Weekly and the Constitution of No Authority. I take apart the Constitution. Definitely check that out. If we take for granted that the Constitution exists, though, then it should be the clear case doctrine, which I articulate in Liberation Library 3, that if a case clearly violates the Constitution, we strike it down. But if there's a question as to constitutionality, let's send it back to the legislature and have them decide it. I think that's the better solution. It's not perfect. Of course, ANCAPism would be perfect. Well, not perfect, but it'd be much better. So now we get into the meat. After that run through the picker bush there, we get to the meat of the opinion. This is my LexisNexis account that I use for doing legal research. Here are the holdings of the case, but I would encourage everyone to read the Heller decision for themselves, because there's a lot of good arguments in there that Scalia makes, and there's a lot of slapping down of Justice Stevens, because he wrote the dissent, and Justice Scalia knew that he was writing the dissent and counters a lot of his arguments, and I think he does so very well. So all these blue areas, for you watching the video versions, these blue areas are where Stevens' name comes up. So here is the opinion, if you can see on the screen. Here's the length of the opinion written by Scalia, and all the blue blocks are where he mentions Stevens and counter-argues him. So I'd go through those, but just to walk us quickly through the bones of what Scalia's opinion was just analyzing the Second Amendment. Here he goes through the procedural posture of the case, the history of the case. Here he splits it up into operative clauses. So let's see if there's the text of the Second Amendment here. Let's bring it up on screen. While we're waiting for that, so let's see. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the Second Amendment right there. He makes a distinction between I'm probably pronouncing this incorrectly, but a preparatory, a preemption, like an introductory clause to this. He says that a well-regulated militia being necessary to the security of a free state. It's a reason why the Second Amendment exists. It's saying one of the reasons why we have the right to keep and bear arms is because we need a well-regulated militia that is necessary to the security of the free state. That isn't the operative part of the clause. That it only introduces the clause. It gives purpose to the clause. Why is that flash wave? It gives one reason why the clause exists. And the actual operative part of the amendment is the right of the people to keep and bear arms shall not be infringed. And so he goes through that. He gives good reasons here that the operative clause, the right of the people, and one argument that he makes is that, well, in every single instance in the Bill of Rights where it says the rights of the people, it's referring to an individual right in every other clause. So why would this right only apply to militias connected to the government if every other right in the Bill of Rights refers expressly to individual rights and not collective rights, as you can see here? And so that's a good one. He goes through the definitions of keep and bear arms. So these are great arguments for you to use if you really want to get in the weeds and argue like the nuances, instead of just saying, well, if you're pro-gun control, then you're not anti-gun. So don't virtue signal at me, because in order to enforce your gun control, you're going to need the state to have guns to take guns away from people forcibly. So I think that's the one argument I would only ever use against a gun control advocate, showing their hypocrisy. And there's no way you're getting rid of guns. And I'll touch on that a little bit as I wrap up here pretty soon. So he goes through what keep means, and then he goes against Justice Stevens's points. So I'm not going to recount all this. I think I've been on for 26 minutes now. It was a little longer than I expected, but so go through, read the Heller decision written by Scalia, and then read Stevens's dissent, which is down here. So read that one. I'll include a link. It won't look like this in the show notes page, where you can read the Heller decision. It won't look how it looks on screen. But so check the Heller decision. And like I said, the Constitution doesn't grant us rights. The Constitution, as in the Magna Carta, only looks back into antiquity and looks back to rights that people used to possess. And if you want to look into that, the whole point of, I already pumped Liberty Weekly and the Constitution of No Authority. That's libertyweekly.net/28. But if you want to look into my episode on the Magna Carta, which was one of the first constitutions, it's more complicated than that, but it's one of the first that people point out as being Constitution-like. So that's libertyweekly.net/58. But to learn the history of people hearkening back to antiquity, the Englishmen hearkening back to the Anglo-Saxon period when they had, natural rights that they thought the government couldn't infringe on. Well, the Constitution does the same thing. It says, and in the Declaration of Independence, Thomas Jefferson says, these rights are pre-existing. It's not, we are recognizing that these rights are pre-existing. It's not that the Declaration of Independence grants rights. It's not that the Constitution grants any rights. The Constitution recognizes rights that are pre-existing. And people really need to internalize that point, that a piece of paper doesn't grant you rights. You have rights because you are a human being. You have rights because you have your faculties. You own yourself. You manipulate your own mind. You control your body. You control your thoughts. You interact with the physical world to homestead things and make them your property, and you exchange voluntarily with others. We don't do that because a piece of paper 250 years ago said that we have these rights. Or because the Declaration says we have the right to life, liberty, and the pursuit of happiness. We don't have, people before the Declaration of Independence had a natural right to life, liberty, and the pursuit of happiness. It didn't come about after the Constitution was ratified. It didn't come to place after the Constitution was ratified either. And so your rights are from your humanity. They're not because a piece of paper 250 years ago that you didn't sign, and all of whom drafted it, all of whom were involved in drafting it, they're all dead now, and several generations dead. They're dust now, and so it's just ridiculous that that piece of paper that we had no contractual consideration for or anything like that. Again, go back to my episode, Liberty Weekly and the Constitution of No Authority, to get more about that. So moving on here, I'm a Second Amendment absolutist. I even think that felons should have their Second Amendment rights returned to them. And I'll say, that might sound like a radical statement, but I'll say it because, if you would not, so you say you have a felon, right? And he's done terrible things. I'm saying he, but it could be, a woman as well. They've done terrible things. Maybe they've murdered someone or something like that. Just because they've done that, if they were walking down the street and someone, well, murder is a different thing, but if they're a violent drug dealer or something like that, I don't know. If they're walking down the street and, not aggressing against anyone, and someone comes up to them and, starts punching them in the face, would you physically restrain that person from fighting back, the felon who's being attacked now? Would you restrain his ability to defend his person against an imminent attack like that? I don't think so. I think you can't remove a person's right to defend themselves. That just goes against all logic. And, otherwise you're going to have to violate the non-aggression principle to disarm them. And I don't think it's right. I mean, of course, sure, if someone has a history of killing people in the past or being violent in the past and they do it again, then a private security firm or, a court or an alternative dispute resolution agency should deal with them however they see fit. Maybe we impose more punitive damages on this person if they have offended in the past. They've committed violent crimes in the past. Well, let's do something else, to further punish them or to provide restitution. Surely we can figure something out, other than disarming them. If they keep doing it, well, maybe that's a different question. I'm not sure how you would enforce that as a private security firm, how you would, make sure that someone is not in possession of firearms. Sure, take every single precaution you can to protect yourself from that person. Maybe I doubt this would happen, but maybe in the future it would come about that the only gun sales, so you get black markets. This goes into prohibition too. You get black markets because you have gun control laws. There are people that will circumvent the law to provide guns to criminals, to felons. There are already laws against felons having firearms, but yet felons tend to get firearms if they really need them. So in the future, and I lost my train of thought here, but so you have prohibition, right? It creates black markets. We know this from alcohol prohibition, from the prohibition of drugs, from the prohibition of guns. In Australia, there's biker gangs that will traffic guns, and it's still super prevalent. Well, if we had no gun control regulations, then every single gun distributor would be legal or legit. You might still have like Craigslist sales or something like that, but who's preventing that anyways? That's still happening. But at least, we have the legalization argument that maybe there'd be a system where in the future, if there's no gun control, all of the legitimate salesmen, all the legitimate gun stores would have this industry standard that they would background check people and figure out, are there any dispute resolution agencies that have had problems with this person? Maybe there'd be a database about who they've aggressed against in the past. Maybe the legitimate gun stores would say, hey, we have a no-serve list. We're not selling to you guys. And then the market would decide if the market likes that or not. So those are my 2 cents, at least. And so like I said, in the show notes page here, I'm going to list all these articles that I've looked at. Oyez is a very good, I think it's the official website for the Supreme Court. So you can go there and get right from the horse's mouth what these decisions mean and what the importance of them are. And if don't take their word for it, go read the opinions for yourselves. And, look, these are all links. I forgot you can't see the screen. Those are all links, all the blue parts, to precedent, and you can fact check it. You can dig as deep as you want, and I would encourage you to do so. So this was a bit longer than I expected it to be. I apologize for some of I'm still getting used to doing this all in one take, so I apologize for some of the rough parts. I think it's just only going to keep getting better as I do this, and improve my public speaking skills and try and get rid of all of the words I rely on, like obviously and stuff like that. I say a lot, so I apologize. But anyways, check out all those linked episodes. I'll try and include them in the show notes page. I'm going out of town this weekend. I want to be back Monday, Wednesday, Friday next week too, with short things like this. I do like this new format. I have some guests that I have lined up as well. Like I said, in the future, I will be doing these current event episodes, and when I have time, I'll be doing specials. But I like the substance that I was able to come out with here about the Second Amendment, and that was impromptu, so we'll see how it progresses in the future. But some ways to help support the site: become a patron of the show. Go to patreon.com/Liberty Weekly. You can get awesome bonus features, marginal utility access at $3 per month. Access to bonuses, the Rothbard repository, also my meme cache and special early release, and I do some video bonuses as well for the patrons. So you can see you become a patron and you can unlock up to I think it's 40 posts or 30 posts on the feed going back a few months. And also, don't forget about that Amazon affiliate link. You can get there by Liberty Weekly, going to libertyweekly.net/Amazon. It's also on the webpage here. And let's see. Oh, keep your eyes open for my appearance on the Sounds Like Liberty podcast, which I'll throw up on screen here, with new friends Nick and Liz. I talked a little music, talked about heavy metal and how that has influenced me and my journey to liberty, and what music means to me in my life. That was a really fun episode. So go check them out. That's at soundslike.libertypodcast.com, spelled just the way you would think it would be. So, all right, well, thanks for joining me. Again, this is the show notes for this will be at libertyweekly.net/63. So that's all for me. Have a happy Easter. It's Good Friday today. All you Christians out there. I think it's Passover as well for all you Jews out there. Have a great weekend, and we'll see you next week. Thanks.